Mr. Lewison.
Sir, I welcome this move to standardize border enforcement provisions across our Intellectual Property Acts, or IP. These provisions allow information and documents possessed by the government to be shared upon request for private purposes such as research or to institute infringement proceedings. I would like to raise questions and comments on amendments relating to the request for information, retention of allegedly infringing goods, and implementing of Singapore's EU-US FTA obligations. Amendments to the 4 IP Acts provide authorized officers or senior authorized officers the power to require a person to provide information or documents for 3 purposes. 1. To satisfy a request for information. 2. To enable actions to be taken relating to future shipment of goods. And 3. For statistical or research purposes. I would like to ask, at the point of request, will the person whose information or document is being requested be informed about the basis for this request? Furthermore, will the period which the information or document be retained be limited to the purpose for which it has been requested for? As for the amendments allowing officers to require the powers to require a person to provide information or documents for a statistical or research purpose, can SMS clarify whose statistical or research purposes these provisions refer to? What safeguards are there to ensure that the information and documents will be kept confidential during the research process? In addition, amendments to the 4 IP Acts provides officers powers to require a person to provide information or documents to fulfill future requests for information to institute infringement actions. How would the officer determine what information or document might be required for hypothetical proceedings? Would this lead to indiscriminate seizure of information or documents? Also, how long would these information or documents be retained for? Would the retention period be subject to the limitation period of potential claims? When the information or documents are obtained, would the person be informed of the possibility that their information will be provided to the copyright holder for the purpose of instituting private proceedings? Next, I understand that the amendments also allow the Director General to provide a person information for instituting an infringement action. The language of the provision which allows the provision of information relating to, quote, any persons connected, unquote, with the import or export of the seized good is very broad. What are the categories of connected persons intended to be covered by this provision? Is there a limit again to the period that a person may request for the information to institute an infringement action? Would a person whose information is being provided be informed of the fact that the information has been shared? The Intellectual Property Students Association, or IPSA, comprising of law students in both NUS and SMU, raised a number of concerns on the retention of allegedly infringing goods after their seizure and detention. Currently, the Copyright and Trademarks Act simply states that the Director General will specify a retention period for the goods, after which it will be returned to the owner unless the objector files an infringement suit. Can the Minister clarify the retention period for allegedly infringing goods if an infringement suit is started? Will they only be released after the decision of the infringement suit is out? In the meantime, what remedy does the importer or exporter have? Even if the goods are released to the original owner pending the decision of an infringement suit, does this confer an automatic injunction on the original owner to sell the goods within Singapore? If yes, does this injunction extend to being prohibited from further exporting the returned goods to another country and selling them from there? This could cause potential losses to the importer and or exporter that may not be sufficiently remedied through the provision of security or damages. One recommendation suggested by IPSA would be to have a review process called an indication, where a committee of our IPOS tribunal has an expedited process for evaluating if the goods are indeed infringing. They can issue an indication, which operates as a non-binding preliminary opinion on the matter. This can inform the objector or intellectual property rights holder and the alleged infringer on how they should choose to resolve this matter. Has the Ministry looked into setting up a similar review process? I also have a number of clarifications to make on the implementation of Singapore's EU-US FTA obligations. This was similarly highlighted to me by the Intellectual Property Students Association. First, Article 10.50 of the EU-US FTA requires customs authorities to adopt a range of approaches to, quote, facilitate the effective enforcement of intellectual property rights, unquote. Under the EU-US FTA, this includes patents. Given that one of the purposes purposes of the bills is to standardize the terms and provisions relating to border enforcement across the IP Acts. Why are the patents not afforded the same enforcement processes as copyrights, geographical indications, trademarks, and registered designs? Further, can SMS clarify why ex officio actions are not provided for the imports and exports of registered designs? Next, there is a minor inconsistency between the definition of counterfeit trademarks goods under the EU-US FTA and the bill. Under the EU-US FTA Article 10.48b, it is defined as goods bearing a trademark that is identical or quote, which cannot be distinguished in its essential aspects, unquote. In contrast, it is defined under Section 3, 5, and 6 of the Trademarks Act as a good that has a sign that is identical or is so identical as to be calculated to deceive. This requirement of an intention to deceive is noticeably lacking from the EU-US FTA definition, which therefore appears to be slightly broader than that under the Trademarks Act. Can the Minister clarify the rationale for deviating from the EU-US FTA definition of counterfeit trademarks goods? So notwithstanding these clarifications, I stand in support of the bill.